Hello, my name is Jane Anderson. I'm based at New York University. I work on intellectual property law largely, but am based also with anthropology and museum studies. I'm also the co-founder with Kim and Kristen Withy of Local Contexts. Copyright law varies from jurisdiction to jurisdiction, though basically there are similarities across all of these bases. So from the United States to Canada, to New Zealand, to Australia, there are some basic principles within copyright law that remain the same. Some things that don't remain the same, however, are time periods for protection. So in the United States and Australia, time protection for copyright is generally 75 years following the death of the author, which can make for a very long period of time of protection. In Canada and in New Zealand, that time period is 50 years plus the death of the author. When copyright expires, works go into something called the public domain. And the public domain is where there is no longer protection or permissions required to use any work. And this means that any work can be used at any time by anyone for any purpose desired. The public domain is often seen as a really useful place for copyright works to go, partly because there are no longer any restrictions on use or on getting permissions. However, we recognise that the public domain poses very particular problems for Native and First Nations and Aboriginal communities. This is because there are no longer any permissions required. Anybody can use anything at any time, and again, bypassing the very particular kinds of cultural protocols that might exist in relationship to how material should be used, the rights and responsibilities that are still associated with those materials. The public domain means basically that people can use your work without asking you for permission, and that they can circulate it and put it into use in any way that could also include derogatory treatment. The public domain presumes a certain kind of form of access, that access is a perpetual good, that anybody can access something is an advantage. But for Indigenous communities, public domain is a real problem because it still means that you have no control over your cultural material. Material that is of a sensitive nature, has restrictions from a community perspective in relationship to how it should be used or how it should be circulated, still can't be added to public domain material. It continues to circulate freely. In fact, that's part of the dilemma of the public domain material, is more and more people can use that material, not less people. And it's harder and harder to bring back the original terms and protocols in relationship to sharing and use from a community's perspective once it enters into the public domain.